Hi, everybody. Dana Sparks, broker of Maximum One Greater Atlanta Realtors and the director of the Real Estate Academy of America. Continuing on with our series on the changes that the Georgia Association of Realtors has made to our contract package for 2025. Please see all the links below for the other videos I have done in this series, along with a link to the schedule of the CE classes we are teaching on these changes from the offered through the Real Estate Academy of America. So today's topic are the changes that the GAR Forms Committee made to the purchase and sale agreement. So let's get started. Not a lot of changes, two pretty big changes, one huge change, one fairly big change. So let me share my screen and we will cover them together. All right. So this is the GAR, Georgia Association of Realtors, Purchase and Sale Agreement, Form F201. And as always, you can tell that this is the 2025 printing. It will have the year at the top, and the very bottom of the page will have if this is the form from the beginning of the year or one of the mid-year revisions. So I'll show you that. Well, I'll just show you that now. At the bottom, see, this says 1/1/25. Okay. First revision is they just made it very general under the earnest money that the earnest money will be paid to the holder. It used to have written out the specific forms of the earnest money. Now it just says in a method of payment acceptable to the holder. In the corresponding paragraph B7, that terminology, they made that change in 2024. For 2025, they added the same language to paragraph A. Always check with the holder prior to writing an offer on behalf of the buyer as to what forms of earnest money they accept. For example, many holders have a policy on if it's a certain amount, it must be in certified funds. If it's over 10,000, it must be a wire, so forth and so on. So check with the holder on their policies regarding earnest money. Additionally, for 2025, GAR added the information. This had already been in there, but just for clarification purposes, that if a buyer purchases a property from a seller and there is a lease, that seller has a tenant in there in a lease, it does state buyer agrees to assume seller's responsibilities in any leases. That's already been in there, specified in this agreement, and the closing, this is what was added for 2025. And the closing of the sale of the property to the buyer shall not terminate any such leases. So buyer's agents, you need to make sure your buyers understand they are taking a lease if there's a lease in that property. Regarding the proration of taxes, GAR further added some clarification language that the party who paid less than their pro rata share of taxes to the other party at closing or collected more than their pro rata share of taxes from the other party at closing shall, upon the issuance of the actual tax bill or any appeal being resolved, promptly pay the other party the amount necessary to correctly prorate the tax bill. So as you know, at closing, the closing attorneys will prorate the property taxes based on whatever the last published bill was. Now, sometimes, depending on the time of year, the new bill has not come out yet, so the closing attorney will estimate based on last year's tax bill. Additionally, sometimes a property owner will have appealed their tax bill and the results of that appeal have not yet come into play. So this new verbiage applies to those situations. All right. This is the biggest change that GAR has made to the purchase and sale agreement for 2025. What's an easy way to remember this? 8 at 8, 8 by 8, 8 by 8. What does that mean? That means that the unilateral right to extend the closing date for 8 days must be given prior to 8 p.m. on the last day of closing. Now, it can be given earlier, but the deadline for one of the parties using this unilateral right to extend the contract for 8 days, that notice must be given to the other party prior to 8 p.m. on the day of closing. Now, again, all of these other issues fall into place. It can't be for any reason willy-nilly. It must be on one of these reasons specified. But again, easy way to remember this is 8 by 8. 8-day extension notice must be given by 8 p.m. Biggest change GAR made to the 2025 purchase and sale. Moving along, regarding the earnest money for 2025, GAR added in just a notice to the buyer that there are financial consequences if the earnest money is dishonored by the bank or not timely paid. And it states, in the event the holder's bank charges any fees related to buyer's check being dishonored, buyer stopping payment, or buyer's failure to deliver earnest money, holder shall notify the buyer, and the buyer shall immediately reimburse the holder the cost of the fees in addition to fulfilling their earnest money obligations. Again, there are financial consequences to the buyer regarding the earnest money being dishonored or not timely paid. Moving along, just a slight change. They changed, this word is now buyer's responsibility to inspect the neighborhood. And under the designated agency disclosure, GAR has, in recognition that a lot of agents work in a team setting, and so it could be, for example, a buyer's agent or a listing agent working on a team. In that situation, they are working on behalf of a larger team with the team leader, and they are one of the team participants. So under the designated agency disclosure section, GAR added that if the broker in this transaction is acting in a designated agency capacity where one or more licensees of the broker are exclusively representing buyer and one or more other licensees of the broker are exclusively representing the seller, buyer and seller consent the same, and so forth and so on. But they added the phrase one or more, again, to account for agents working as a team. This default section, this was actually a change from July of 2024, the mid-year contract changes that GAR made last year under remedies of a buyer. So if a seller defaults on a contract, they've added an additional remedy for the buyer, and that is that the buyer may pursue any other remedy available at law. So if a buyer defaults, the seller's sole remedy per the contract is to retain the earnest money as liquidated damages. If a seller defaults, the remedies for the buyer is number one, to sue the seller for specific performance. If that's the case, the earnest money stays in the deal, and a judge decides, it goes to court, and a judge decides if they're going to force the seller to go through and honor the contract or not. That's what specific performance is. Or the buyer may terminate the contract and get their earnest money back. And this new additional remedy, buyer may pursue any other remedy available at law. Typically, that refers to a buyer legally pursuing a civil situation with the seller for other financial damages. Again, that was added July 1st, 2024. And then the other provisions, paragraph C4, this is the other big change that GAR made for 2025. Delays caused by emergencies. In the event the governor of Georgia declares a state of emergency for the county in which the property is located, all time deadlines herein, including but not limited to the closing date, shall be automatically extended for the number of days, the emergency exists in that county. Nothing herein shall prevent the parties by mutual agreement from proceeding forward without extending such deadlines. This is a good, in my opinion, this is a really good addition. If we think about some of the state of emergencies that happened in 2024 and actually in the beginning of 2025, there are situations where the power and internet are completely knocked out, and it would be impossible for the parties to actually sign any extensions. So this is automatic extensions if the county is declared a state of emergency for the number of days that that county is under state of emergency. Some other minor changes: digital signatures, it used to say electronic, so forth and so on. This paragraph about the GAR forms, that's one of the universal changes I've already addressed in another video. This is a new paragraph, no recording of agreement. This states that a buyer shall not record or permit to be recorded this agreement or any other memorandum or summary thereof in the Office of Land Records. Buyers shall be liable for damages for violating this section of the agreement. Nothing herein shall prohibit the buyer from recording a lis pendens as part of filing a lawsuit claiming an interest in the property. There's a lot of legalese to this, and in essence, what this means is if a buyer does pursue the seller legally with some sort of lawsuit, a lis pendens does get recorded with the property. But there were some situations where a buyer was following, it's called a notice of settlement, but basically a buyer was filing a claim to the property just to tie up the seller from selling it to somebody else. And in essence, that's what this new paragraph prohibits. This paragraph, property to be delivered in clean condition, this verbiage had been in the purchase and sale agreement. However, it was in the damages paragraph, and a lot of agents missed it. So GAR just teased this section out. I just want to remind you, please also check out GAR Special Stipulation 720, property delivery condition. That might be a special stipulation that you would want to include maybe in this purchase and sale, but definitely if you are using a temporary occupancy agreement for the seller after closing, you'll want to check out that GAR Special Stipulation 720, property delivery condition. And rules for interpreting this agreement. In essence, what has been added is some verbiage with respect to compensation. In essence, that if the buyer and the seller have negotiated compensation to the buyer's broker specifically or the seller's broker within the context of the purchase and sale agreement, that can only be changed with signatures by the brokers who are impacted. In other words, a buyer and seller can't do an amendment changing compensation to one of the brokers without that broker's written consent if it's impacting that broker. So that's what this additional verbiage is. 2025, this paragraph 6 has been added, that except otherwise provided herein, this agreement and any amendment thereto shall be enforceable as between the parties, even without the signature of any broker referenced herein. Notwithstanding the above, if any provision in this agreement, including a provision in any amendment, changes the total amount of compensation due to any broker from the total amount of compensation said broker had previously agreed to in writing, then such change to the broker's compensation shall only be binding if the broker impacted by such change consents to the same in writing. If a buyer's broker compensation agreement F-259 is attached as an exhibit to this agreement shall not be enforceable unless this agreement is signed by the broker paying or receiving the compensation thereunder and it has been initialed. These other two paragraphs, 7 and 8, again, had already been included in other sections in the purchase and sale agreement. Statute of limitations, again, reduced from 2 years to 1 year. That's another universal change already addressed. And again, a universal change above the signatures is a reminder to entities signing a legal entity how they are to sign. So that's it for changes to the purchase and sale agreement. Again, two biggest things are 8x8 extension, 8-day unilateral extension notice must be sent prior to 8 p.m. last day of closing. And if the governor of the state does declare the county a state of emergency, all deadlines automatically get extended for those number of days. So, curious what you think. Comment below your thoughts on the changes to the purchase and sale agreement. Thank you so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education. Bye. If you like that video, check out the one here. If you like the content on this entire channel, please click here to subscribe. I try to take even the most complicated of real estate situations and make them crystal clear. See what I did there? Real estate made crystal clear. Thank you guys so much for watching.